And thanks for having us, everybody. Pleasure to be here. And as Shelby said, you're welcome to unmute yourself and interrupt with questions as we're going over some of this information. That doesn't bother us at all. Or you can wait until the end. Either way is fine with me. But sometimes it might be more appropriate as we're talking about something, if you want to interject, give us an example of something that might have happened at your workplace, or have a specific question about a topic that we're talking about at the time. Please feel free to jump in and ask the question at that time. As Shelby said, I'm Bryan Niemeyer. I practice labor and employment law for FGKS Law. We just sort of went through a rebranding because Faulkner, Garmhausen, Keister, and Schenck was too much of a mouthful, as Shelby just showed us there. So FGKS Law is perfectly acceptable, Shelby. And as she mentioned, we did open an office in Troy. We have 14 attorneys. We are a business law firm. We represent companies. I represent companies in labor and employment law issues. And also with us today is Colleen of our office. She's an associate with our firm, been with us for a couple of years, and she's sort of my right-hand woman with regard to these labor and employment law issues, and provides a lot of help for me in terms of research and so forth. And particularly in these last couple of months with all the COVID-19 issues, she's been a huge help. And I have to give her credit because, number one, she prepared this presentation that you see on your screen if you have access to it. But number two, and perhaps more importantly, she's actually on vacation in Hilton Head right now. And she has willingly, without any coercing from me, she's willingly agreed to participate. So with that, there's one non-COVID-19 related issue that we wanted to just bring to your attention because it is so recent, and it's a landmark decision from the United States Supreme Court. And if you've been to any of our presentations over the last year or so, we've mentioned that the Supreme Court was going to be hearing a significant case regarding gender identity, sexual orientation, and that we anticipated a decision sometime in June of 2020. Well, right on cue, the Supreme Court just last week rendered its decision in this case, and Colleen has read the decision, and I'll let her just sort of briefly summarize for you what the Supreme Court held.
Yeah, so the main takeaway from that decision that came out, as Bryan mentioned last Monday, was that Title VII, which prohibits employment discrimination on a series of things, race, religion, etc., but it also prohibited employment discrimination on the basis of sex. And for a long time, there's been a question as to what does sex mean? Does it just mean male, female? Does it encompass sexual orientation and gender identity? There's been a circuit split across the United States. It's been pretty unclear for employers what they could do, what they couldn't do, and depending where you were, what state, what circuit, you were allowed to do certain things or not do certain things. But the gist of it is that the Supreme Court decided that on the basis of sex, in terms of employment discrimination, does indeed include sexual orientation and gender identity, meaning, you can't decide to fire someone just because he or she is transgender or is a homosexual. So that's something we had presented specifically to the Troy Chamber before. And the Supreme Court kind of surprised a lot of people with its decision. So that's just something to keep in mind going forward when making employment decisions, is that sexual orientation and gender identity are now protected characteristics under Title VII.
Okay, so that definitely gave us some clarity in that regard with regard to that issue, because the federal courts across the country were split on whether gender identity and sexual orientation were protected classes under Title VII, and the Supreme Court has now told us that they are. So now we know, and we have to plan accordingly. So with that, we'll move on to sort of the topic of the day, the COVID-19 stuff. And the first issue that we wanted to talk about was bringing employees back to work. And one question that I've gotten a lot over the last couple of months is, what's the difference between a furlough and a layoff? And sometimes those words are used interchangeably. Generally speaking, a furlough is a very short period of time off of work. I like to use the example of, when a factory shuts down for a week or two, a lot of times some of the companies like Honda and some of the bigger companies might have a shutdown week, maybe around the 4th of July coming up here in the next week or so. And their employees are off for a week or two. That is generally considered a furlough, when someone is off for a very brief and definitive period of time. A layoff is more indefinite. We're not sure when or even if the employees are going to be called back. So that's sort of the technical difference between the two. If you have a policy that provides for payment of accrued leave upon termination of employment, you should probably pay that to your employees when they are laid off, but you don't have to pay that when they're furloughed. So that's sort of, from a legal standpoint, that's the significance of a furlough and a layoff and the difference between the two. And again, I've had that question come up quite a bit over the last couple of months because of all the furloughs and the layoffs that companies have been doing. Another question I'm getting quite a bit is, the unemployment benefits. As we all know, the federal government has provided folks with this $600 weekly stipend. If they are collecting unemployment benefits through the state of Ohio, they also get an additional $600 a week from the federal government under the CARES Act. And that has created a lot of anxiety among employers because of the concern that employees really are disincentivized to return to work because they are in effect earning more money sitting at home collecting unemployment than they were when they were actually working and earning a paycheck. And a lot of the questions that I've been getting from folks is that, well, gosh, how can I get an employee to return to work if he or she is making more money at home on unemployment with their unemployment benefits? And my response is always, well, the employee does not control whether they are going to continue to get unemployment benefits. That ultimately is up to you as the employer, whether someone is entitled to unemployment benefits, because if you offer them a job to return to, for example, if they are on a layoff and you offer them their position back, at that point in time, they are no longer eligible for, sorry, my cell phone just rang and I lost the heating. Can you still hear me? All right. I'm back in. Sorry, let me turn my phone off. I apologize. Power down. Okay, so ultimately it's up to the employer to determine whether someone is able to collect unemployment benefits. As I was saying, once you offer someone a job to return to, at that point in time, they are ineligible for unemployment. Now, it may take you having to contact the Department of Job and Family Services to advise them that this particular individual was offered a job to return to. But technically, from an unemployment standpoint, they are no longer eligible for benefits. And ultimately, it's up to the Department of Job and Family Services as to whether someone is entitled to unemployment benefits or not. So there are many different scenarios at play these days with folks staying home due to COVID-19 concerns. Sorry, I got phones ringing all over the place. So there are many different issues that come into play, and many different scenarios where employees are or may not be eligible for unemployment benefits, and you as the employer have the ability to control some of that, depending on what job is available for them. And ultimately, in order for them to collect benefits, they have to be ready, willing, and able to work. So if someone is not working because of some sort of health issue, arguably they are not ready, willing, and able to work and are no longer entitled to unemployment benefits. And by the way, the $600 additional federal stipend under the CARES Act expires as of July 31st. There has been some discussion about continuing that beyond July 31st, but at this point in time, that is the end date for that additional $600. with regard to recalling employees, another issue that has come up a lot over the course of the last month or so, particularly as companies have started to reopen their doors. If you are being selective in terms of who you are recalling and you're not recalling your entire workforce, one thing that I want to point out to you is that it is critical that you document why you are selecting certain folks and how you are selecting certain folks. It's best to have some sort of objective criteria that you're using to select who you are. If you're not bringing everybody back, you don't want to be in a situation where you are selectively picking folks, and maybe unwittingly you're not selecting folks that might be in the protected age category, or you might be bringing more males back than females, or vice versa, and that in and of itself could give rise to a possible discrimination claim, because your policy or practice of recalling employees is having a disproportionate impact on a certain group of people that are in a protected class. So you want to be very careful and very conscious about how you are recalling your employees, how you're bringing them back. It's best to have some sort of objective criteria, as I said, such as maybe by seniority, by job skill. Maybe you want to utilize their attendance history, their prior discipline. There are different criteria that you can use for that selection process, but you want to be very detailed in how you go about doing that, and try to document that process as best you can, so that if you are hit with a letter from the EEOC or the OCRC, the Ohio Civil Rights Commission, you have documentation to point to that says, no, I was not making any decisions based on age, based on race, based on gender. Here are my objective criteria that I use for that selection process, and this is why these folks were selected and these folks were not.
Bryan, I have a question.
Yeah, go ahead.
Regarding what you're saying, so proper documentation. So if I contacted an employee and said, I'd like you to come back, and they refuse because of what you just mentioned as far as the pay goes, do I have them sign something in regard to that as proper documentation, or what would you suggest?
That's a good question. I don't know that I'd necessarily have them sign something, but I would follow up in writing. I would follow up with a letter or an email confirming that, hey, on this date, I offered you your job back. You refused because you wanted to stay on unemployment. And I mean, as far as I'm concerned, that's grounds for termination. That's job abandonment in my mind. We told you we want you to come back, and it's not the employee's choice to, no, I'm good. I just want to collect unemployment. Give me a call back on July 31st when this $600 runs out. But it's not their choice. So in my mind, that would be job abandonment, and I think you would be well within your right to tell them, well, if you're not accepting this offer to return to work, then I'm going to consider that your resignation of employment. And then I would follow up with an email or a letter to that effect.
Okay, thank you.
Yeah, good question. So that's a good segue actually into the next topic here that we wanted to discuss, and that is when an employee refuses to return to work. And maybe it's not a situation that Bill just mentioned about, just because they want to stay on unemployment, but with all the COVID-19 stuff that we're dealing with, and the health and safety concerns, maybe the person is 70 years old, or maybe they have asthma or some sort of medical condition that is in that high risk category as defined by the CDC. You have some ADA concerns that you need to at least explore. If an employee says, I can't come to work because of X and it's a health condition, well, we need to figure out, is there a way that we can accommodate that individual's medical condition that would allow them to return to work? Can we allow them to work from home? There are certainly some ADA implications with this COVID-19 and people not wanting to come back to work. I've also had employers ask me, well, gosh, this person is 70 years old and, he or she's a good employee, but I don't want to bring them back because I'm concerned about their health. Well, at the end of the day, it's not our job to dictate whether someone should or should not come back to work for a health reason. We are not doctors, right? Ultimately, it's up to a physician, and it's up to the employee to request an accommodation. If the employee, a 70-year-old, wants to come back to work, it's not our place to say, you know what, you shouldn't be coming back to work because you're a high health risk. You should really stay home. I'm not going to allow you to come back to work. Well, you now just potentially have gotten an age discrimination claim on your hands. If this person decides to go see an attorney, they have a legitimate age discrimination claim. Because again, we can't just tell an employee, it's not our decision to say, no, I'm looking out, even though you're trying to be benevolent and you might be trying to do the right thing, you have to be very careful in telling people that they shouldn't come back to work because of their age or because of their health. When it comes to medical conditions, there are ADA issues. When it comes to age, there's age discrimination issues. So just be mindful of that, that there are some issues out there that we have to explore. If it's a medical issue, hey, how can we help you? How can we get you back to work? Or is there anything we can do to help you to return to work that's going to make you feel better? So I just point that out because that has been a hot topic, a hot button issue, and I've gotten a lot of questions in that area. And just I wanted to at least arm you with the knowledge that if that issue comes up, those are issues that have to be dealt with on a case-by-case basis, and you have to be sensitive to the potential ADA and age discrimination issues. Another issue that has come up quite a bit is recently are the face mask. Employees refusing to wear a face mask, and I'm going to turn it over to Colleen and let her talk a little bit more about the face mask issue.
Thanks, Brian. So as Brian said, face coverings, they're obviously very prevalent in society right now, and you will probably find that a lot of employees don't want to wear one. Maybe they just flat out don't want to. Perhaps they have a reason as to why they cannot wear one, or at least they say they can't wear one. So right now in Ohio, as I'm sure you all know, Governor DeWine is requiring that all employees wear a cloth face covering unless they meet one of the 6 exceptions. And so the 6 exceptions, they're all listed right there. I won't read them to you because I'm sure you've seen them before. But so there is potential, a potential reason as to why an employee cannot wear a face mask. Say perhaps it's for some medical reason, or they work in a very isolated area. No one else is around them. That would be another reason as to why an employee might not have to wear a face covering. But the most important point I want to emphasize with regards to face coverings and employees who don't want to or say they can't wear one is that you need to have written justification as to why an employee meets one of these 6 exceptions. Just in case the Department of Health decides to come in, or perhaps you have a disgruntled customer, or right now, Brian and I have seen cases where a former employee or customer might blow the whistle on a business and say, hey, their employees are not wearing face coverings. So it's important that you have written justification. And that's, it doesn't have to be super detailed. And one that Brian and I have run into a lot is in regards to the, a health reason. Wearing a face covering is not advisable for a health reason. That's pretty broad. And even with that, you don't necessarily need a doctor's note or anything. You just need to have some sort of written justification that you could potentially provide to a local health official upon request. And again, especially, the face coverings are a pretty tricky issue to deal with, especially in situations where an employee might have a valid reason as to why they can't wear one. And the best way for you as an employer to protect yourself is ensure that you have that written justification that you can produce to, a local health official upon request, sure, if they were to request it. So another kind of on the other end of the face coverings is, what about face shields? I don't know if you guys have seen those. They're giant plastic, really it's a shield over an employee's face, but it's open air. So for instance, sometimes if I wear my glasses and a face mask, the glasses fog up. So, what about using a face shield as an alternative? And right now, technically, they are not an acceptable alternative in Ohio, as the Ohio requirements for all the businesses and employees specifically describe a face covering that is made of cloth and covers an employee's mouth and nose. So right now, it's not within the realm of the Ohio requirements. But if there is a reason as to why an employee cannot wear a face cloth covering, a face shield is better than nothing. Potentially, if you can get a hold of one and they're willing to wear one. It's not necessarily required, but with all the different measures that businesses and employers are taking right now, it's better to be safe than sorry in terms of providing as much protection as you can and demonstrating that you did everything possible in order to help protect your employees. So in other states, public health officials, at the state and government level have said that face shields are acceptable alternatives. We haven't had that in Ohio yet, but again, it could be a good alternative to consider if there's another reason as to why employees can't wear one of the cloth ones that covers your face. So, and as I mentioned, Governor DeWine and the Ohio Department of Health have not issued any statements regarding face shields, but perhaps as the summer continues and the temperatures rise, perhaps they'll explore that a little bit more and give us some more guidance on that issue. So, and along with, the face coverings, especially say there is an employee who can't wear one because of a health reason, do you have to provide a special accommodation for them, if they can't wear the face covering? And not assuming that there are no other underlying ADA issues at play that you would have to accommodate, you do not necessarily have to make a special job for this employee in order to ensure that they're not working near other people without wearing a cloth face mask because they can't. But that being said, if you do have the ability to let the employee work in the back room and stock shelves or some other job where they're not breathing in air around other people, that would be a good thing to consider. If you can provide them with some sort of special job that they can do without wearing a face cloth mask and they be a little bit more isolated, that's a good idea, but it's not required. Another question we've received is, can I fire an employee who comes back to work and refuses to wear a face covering? And assuming that that employee meets one of those 6 exceptions that were on the previous slide, you cannot fire that person, even though it might make you very uncomfortable and you're reluctant to have someone in your business who's an employee and they're refusing to wear a face covering. If they have a documented, written justification as to why they can't wear it, then you cannot fire them. So another issue besides face coverings, which is a really prevalent one, and anytime I've had to wear one, they're kind of itchy and they're sweaty and they're not fun, but they're necessary right now. So that's something that's important. But as we're kind of returning to this new normal, another issue that's really popped up quite a bit are return to work waivers, which I'm going to hand this back over to Bryan and let him discuss those a little bit.
Okay, thanks, Colleen. Just a couple of quick comments with regard to the face mask before we go to the next topic. As Colleen mentioned, that has really become a hot button issue just in the last couple of weeks, especially as the weather's gotten more hot. You're talking about manufacturing facilities. If it's 85, 90 degrees inside working and you have safety glasses and your glasses are fogging up because you have a face mask on, that creates other real safety issues. And I've had some clients that have just flat out said, you know what, we're done. I've had too many complaints. I had an employee pass out due to heat exhaustion because they're wearing the face mask all day. I'm done with the face mask. And in that particular instance, it was actually a Miami County employer, and the Miami County Health Department sent a college intern out to the facility. So that tells you, I guess, what level of importance the health department might be considering some of these issues. But they really didn't do much about it. The message was, well, do the best you can do. And as long as you're taking some of the other precautions, a face shield would be a great alternative if you can get your hands on them. But I just wanted to mention that, that is really becoming an issue, and it'll be interesting to see how long this face mask requirement remains in place. So moving on to the return to work waivers, And that's a question that Colleen and I have gotten from some of our clients, is whether these waivers are something that we should be doing, having employees sign some sort of release or waiver that, hey, you know, if I come back to work, I'm not going to sue you for catching the virus, the COVID-19 virus. Our recommendation has been not to have those waivers signed. I just don't think they're worth the paper they're printed on. Number one, if an employee can prove that he or she contracted the virus while at work, then it's a workers' comp claim. And they're limited to whatever recourse they have in the workers' comp system for contracting an occupational disease. So they can't sue you for contracting the disease at work. And I'm afraid that, you know, if you have employees sign these waivers, even though they're unenforceable with regard to the workers' comp, an employee cannot waive his or her rights under the workers' comp system in Ohio. So a waiver would be useless in that regard. But also, I'm concerned about what it would look like for the employer when the employee said, well, they had me sign this waiver. I mean, it's almost, to me, it gives an argument to the employee and the employee's attorney that, hey, the employer was trying to skirt some of its obligations and having us sign these waivers. I just don't think it's a good look for the employer. You also have under OSHA's rules and regulations, there's a general duty clause that you have a duty to provide a safe workplace free of any health risk. So, you know, as long as you're complying with the current Stay Safe Ohio order, you know, I just don't see the need for a waiver. And in fact, I think it potentially could do more harm than good for you. So our recommendation to our clients has been, you know, don't have your employees sign anything when they come back. Just do the best you can complying with the order. And, you know, if you have employees who are showing up and they have symptoms, send them home. And if you're aware that someone is test positive, well, they got to self-quarantine. They can't come back to work until their self-quarantine period is over, and you can require them to have a doctor's note that they are no longer at risk to spreading the virus. So we wanted to just bring that up with regard to the return to work waivers, because that has been an issue that we've seen with quite a few of our clients as well. So I'm going to kick it back to Colleen, and then we'll wrap it up and open it up to any questions that we might have.
Thanks, Brian. So kind of moving forward, again, this is all, you can't, you know, at the beginning, I thought we could, you know, just say, oh, can't wait for things to return back to normal. But I think at this point, it's pretty clear to everyone that there's not really a return to the normal as we knew it. It's a return to a new normal. And so moving ahead, what's the best way to go about that? And first, and Brian kind of touched on this, adhere to all the as best you can to the guidelines and mandates that are set forth by the CDC, Ohio Department of Health, Governor's Office, all of that. You know, that Ohio especially has been pretty, you know, at the forefront of issuing a lot of mandates for employers and businesses. So they're giving you, you know, these guidelines that, you know, if you have those and you're following them as best you can, that is one of the best things that you can do moving forward, not only to protect employees and customers, but, you know, just as a matter of good practice for your business. And another thing that kind of goes hand in hand with some of those mandates is encouraging good hygiene among employees. I know it's very hard to obtain hand sanitizer right now and cleaning supplies, but to the extent that you are able to find them, make them available throughout your workspace, and, you know, perhaps implement a cleaning schedule, you know, divvy it up among your staff and say somebody wipes down the high touch surface areas such as a microwave or the printer. Somebody does that once a day. And then in addition to doing these kinds of things, it is important that you document your efforts to adhere to these guidelines. You know, send an email to your employees saying, these are the steps we are taking in order to protect you and, you know, our business and our customers. You know, post throughout your workspace the little CDC mandates that, you know, make sure you wash your hands and use hand sanitizer after you sneeze, and all those kinds of things. Documentation, you know, you can only do so much in terms of, you know, you can't force all of your employees to, you can't stand in the bathroom with a timer for 20 seconds and ensure that they're washing their hands for 20 seconds. But to the extent that you can provide these reminders throughout your workspace that they should be taking those steps, as we return to this new normal, that's one of the best things that you can do going forward. And then also communicating with your customers or your clients as to these steps that you are taking in order to protect them from potential exposure to COVID-19. Whether it's an email to your client list or having having a sign on the door of your office, saying that these are the steps you're taking. All of these are ways in which you can, better protect your business moving forward. And so with that said, if anyone had any questions, they can either chime in, or perhaps Shelby, you got some in the chat box, but Bryan and I will be ready to tackle those, hopefully.
We'll wait a couple minutes here and see if there's any questions that come up in the chat. But thank you both so much for doing this. That was great.
I actually have a few.
Go ahead.
That I kind of jotted down. So if an employer is not enforcing mask or social distancing, does an employee have recourse?
They can report it to the health department.
Right, that's kind of what you said earlier, but not
Yeah,
really.
there really isn't any recourse. Under the Stay Safe Ohio order, it is a second-degree misdemeanor for someone who does not comply with the order. Now, in a corporate setting, I don't know, does the owner get criminally charged? I don't know how that logistically would work. But technically it's a second-degree misdemeanor with punishments of up to 90 days in jail and I think a $750 fine. But really the recourse is at this point in time to contact the health department. And as I mentioned, at least the feedback that I'm getting from some of my clients is that the health departments do not seem to be terribly concerned. I shouldn't use the word concerned. They're not really out there looking to bust employers and to make it a criminal issue. I think they're trying to work with employers to help come up with measures or alternatives to protect the employees if the masks are deemed to be impractical. Mm-hmm. And that's one of the exceptions that Colleen talked about or was on the slide was it's sort of a catch-all exception, is that if it's impractical to wearing a mask, then it's not required. Well, you and I might have different versions of or different definitions of what's practical and what's not practical. But I think in the factory setting, when you're dealing with the high temperatures and safety glasses, people working around heavy equipment, you can certainly make an argument that it's not practical to wear a mask in 85, 90 degree heat when my safety glasses are fogging up. It could create other potential safety risks. So does that answer your question?
Yes, and it was particularly the factories, just the high temps and
right,
and certainly that issue. I have another question. If your employer requires a negative COVID test if you travel out of state before you come back, is that something that is within their means or within their rights as an employer to require that?
Colleen, you want to address that? Have you come across that?
I have not come across that.
Okay. I would say if they're just traveling out of state, I mean, at this point in time, crossing state lines is not something that is, it's not something that the state of Ohio is requiring employers to self-quarantine. Now, at one time it was. Right. Now it's not. There's a recommendation for a self-quarantine period for those traveling out of state. But someone's just driving out of state for a weekend or even a vacation, and they're not getting on an airplane and going to some high-risk area. I would not require them to have a negative COVID-19 test before returning them to work. You could certainly take their temperature when they come back. And ask the questions, were you exposed, so forth. But now, is it against the law to require a COVID-19 test before they return to work. At this point in time, who knows? I don't think so. But you know, we just, there's limited guidance. We certainly have no history to fall back on as far as how courts might interpret this.
Right.
But you know, I could envision some sort of ADA issue, or if it's an elderly you know, not elderly, if they're in that high risk of 65 or older, you know,
Or work in healthcare.
Yeah,
You know,
correct,
in a skilled nursing setting.
correct. So, you know, I don't think that's problematic. I don't think that's illegal at this point in time, but is it necessary? Probably not, in my opinion.
Okay. And then that brings me to just one last question. Many people in different types of healthcare settings, we have the hospitals where people have been furloughed, but then you have the nursing homes where people have put in extra hours. Is there working more hours, what is the employer's duty or responsibility to the employees that are salary, that are putting in 60, 70, 80 hours a week at the same salary as pre-COVID?
Yeah, that's a good question. As long as they're salaried exempt, you don't have any additional obligations to them. Now, you might have some, I guess, ethical or moral obligations to try to keep your employees happy. But if they are salaried and they qualify as exempt, and let me clarify that just because someone is paid a salary does not mean they're exempt from overtime. They also have to meet one of the exempt criteria under the Fair Labor Standards Act in order to be an exempt employee. The salary is just one component of that. So if we're talking about salaried exempt employees, no obligation to pay them anything more. I mean, you might feel compelled to give them a bonus if you want to keep your morale up and keep them happy, you know, pay them a little bit extra, but you have no obligation to do so. Now, if they are salaried and non-exempt, you still have an obligation to pay them overtime for any hours worked over 40.
And where would you get the criteria for exempt or non-exempt?
Well, there are several exemptions that one might qualify under the Fair Labor Standards Act. If you would shoot me or give me your email or.
Well, I'm just asking general.
Well, it's not something that I could answer.
Gotcha.
There's an administrative exemption. There's an executive exemption. There's a professional exemption. Those are sort of the main ones. But there are several criteria within each exemption that an employee has to satisfy in order to qualify as an exempt employee. They, you know, under one of the exemptions, they have to supervise 2 or more employees. They have to exercise discretion for a significant part of the business. You know, usually you're talking about management level people and above. Some supervisors, as long as they're not working supervisors and spending most of their time actually doing non-supervisory type work. So there are a lot of traps for the unwary there, and it's not something that I can
I understand. Okay.
in a simple fashion.
Sure. Thank you.
I do have something that I could send you, that I have sort of a memo that I've prepared for clients in the past that summarizes the different exempt criteria. And I'd be happy to send that to you.
Okay, awesome. Okay, that's it of my questions that I jotted down. Thank you.
Good questions. Thank you. Anyone else have anything? Nothing in the chat box, Shelby?
Oops, I'm sorry. I'm going to ask one more.
All right, good. Fire away.
Hazard pay. Have you heard anything about the requirements of employers to pay hazard pay, or is that something that would fall under this discussion?
Yeah, it is. And I have heard, you know, that topic brought up. Again, that's something that's discretionary. It's up to the employer whether you want to pay it or not. I know some of my clients have paid hazard pay for folks who maybe return to work and you know, they were, and those questions seem to come up maybe a month and a half ago. Not so much lately as things have reopened and companies have started back up again. But when there was essential and non-essential employers, and you know, some of the essential employers were having their employees come back to work. I do know that some of them gave some hazard pay, some additional compensation as an enticement to get folks to come back to work. But quite honestly, I have not had that issue come up in probably the last month or so.
Okay. Thank you.
Yep.